The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic:
Dear Mr. Premack, I had an elderly friend who owned several rental properties. She died in early 2007 without a will and has no known legal heirs. The properties are vacant and the taxes have not been paid since her death and will soon go to the state of Texas. Is it legal for me to apply to be the administrator of her estate in order to protect her properties by paying the taxes and then selling them? How much will it cost me? Thank you very much for your help. G.E.W. Texas law allows any interested person to apply to become an estate's administrator, which at first impression sounds hopeful for you, but in fact you face two legal obstacles to becoming administrator. First, the Texas statute defines interested person as including only heirs, devisees, spouses, creditors, and others having a property right in or a claim against the estate being administered. Since you say there are no legal heirs, you admit you're not an heir. There is no will, so you are not a devisee. You describe yourself as a friend, so you are neither the decedent's spouse nor a creditor of the decedent. Again, as a friend, you have not claimed that you have a property right in her estate or a claim against her estate. You want to help settle a situation that you find unacceptable, but since you are not an interested person as defined by law, you are not legally authorized to take the actions you desire. Second, you say that your friend died in 2007. Texas law allows the court to appoint an administrator for her estate only if 1. The court action takes place within 4 years of the date of death, or 2. Even after 4 years, if the court action is needed to recover or receive funds which are due to the estate. In your situation, the estate owes taxes, but there's no hint that money or property is due to the estate. Thus, the 4-year limit on appointment of an administrator also bars you from taking the actions you desire. You cannot become administrator of the estate, but you still desire to know what will happen to the rent houses that your friend owned. You think they will go to the state of Texas, a legal process known as Escheat. You're probably correct. The county may take judicial action to foreclose on its lien for unpaid property taxes, or may file a petition for escheat in the district court. Under the Texas law, if the court finds that your friend died intestate and without heirs, title to her houses is treated as though it passed to the state on the date of her death. Note of interest: many people are becoming more reliant on the cloud to track and store information like photographs, documents, and emails. Legal scholars are aware that your valuable information is often left to the whim of the companies who operate the cloud services. Google, as one of the largest providers of cloud storage, has recently announced a new policy regarding inactive accounts, which can mean the account of someone who died. Their new settings allow you to decide on a grace period during which they will treat your account as active, even if you have not accessed it. If the grace period is passed, they will try first to contact you at the address you provided to them, and will notify the trusted contacts you provide to them. If no action is taken, you can tell Google to delete your account and all information in it. Do an internet search for Google Afterlife Account Manager to set up your own preferences.